myself in their shoes and say, well, okay, well, what's this access? Tell us about it.
And you're quite right, Ben. You know, it's got to be traceable.
You're not going to get access. So in that particular case, I would argue it's unreasonable.
Well, it's the failure to agree or disagree, which the Act has to deal with.
Is there a probability, once you've looked at all the evidence?
They haven't given me permission.
Can the building owner say, okay, you've got to sue me?
The letters of appointment are just your standards. They should be bespoke.
Am I legally entitled? Am I allowed to deal with this damage?
The quality of their work is not being looked at by somebody who can assess it.
This is a cracker. What a question.
At that point, it becomes a scam, in my opinion.
Welcome back to part 2. Let's get to it.
Yes, a great article. Shall we move on to question 3, which is under section 10.4. What steps should the surveyors take to settle a deemed dispute? I like that question personally in relation to 10.4 because I was appointed under 10.4 and I do this thing of doing a cursory inspection. Like we send a letter to someone's house to say, look, you haven't responded and we're going to attend your property to grab some pictures. And what happened was I stood outside, grabbed some pictures, and a lady sort of opens the window. What are you doing? And I'm just here to grab some pictures. Happy to have a chat with you at the door or anything, because it's probably a little bit unsettling, to be fair, to have someone like me grabbing pictures, of your property. I don't think I'd shave that day either, or I was, whatever. I probably didn't look that great. And she's like, "What is this person doing?" Right? And it made me realise that actually, like, how I'm coming across could be a little bit on the intrusive side, right? And she just said, "Look, I want you to delete all your pictures." I said, "Yeah, absolutely fine. Do you know what? You're telling me to delete basically evidence of the condition of your property, but I am going to do it because I believe that the person instructing me is the adjoining owner who hasn't responded, right?" So I say to myself, "Yeah, I will. I guarantee I'll delete everything," which is what I did. No evidence whatsoever. And it made me think to myself, like, the normal process of a party wall surveyor under section 10.4 is to try to get entry into a property, and often they gain entry through tenants or people that are just, I could have been let in on that day by a tenant, right? And what would have happened if the the adjoining owner whose property I had inspected, they haven't given me permission. And the nature of 10.4 appointments is such that you don't really have communication with someone most of the time. They simply don't get in contact. And it's almost like similar to that award with Evans versus Patterson, where it just lands on your desk and you're just like, what's this, or perhaps they just don't really care, whatever it is. But so it can be a bit of a shock for people. And really the thrust of this question, which is what steps should surveyors take to settle a deemed dispute? Like, I'm approaching it from an angle of, is it okay for us to, do these schedules without the express permission of the adjoining owner? Is it okay for us to undertake monitoring, which is for me basically surveillance, of a neighbour's property, because we're trying to protect their property, but actually the actions that we're looking to do can be seen as sort of intrusive and borderline aggressive if taken in the wrong way. So that's kind of why I put the question there, and I wanted to know your views, really.
Yeah, I mean, I realise in the context of the question now, it's made me think, but I mean, my initial thoughts were, well, if you're appointed under 10.4b, and therefore you go about as best as you can, and it's reasonable, to produce eventually an award which defines the rights and obligations of the building owner, his rights and the obligations they owe to the adjoining owner. But the question is very much a legal one, I suppose we can put to Edward. This thing about photographs generally in the context of what Ben has just described, and we now are paranoid as surveyors about not including photographs in schedules of condition, but we say they're held on the files of the surveyors. Is it a GDPR situation? Is it something else?
Not so far as I'm aware. I mean, there is no general law of privacy yet, and the courts are moving towards the laws of privacy. But there's no absolute right to require somebody to remove a photograph of the outside of your building, for example. There are laws relating to children, of course, but that's a different matter. You can't take a picture of a child on the basis that you're taking a picture of the building behind the child. But no, as far as I'm aware, there is yet to be a general law of privacy which provides that you can't take a photograph of somebody's house without their express permission.
So you said outside, but I mean, would you
Now,
apply
if
that
you're
to
going
inside as well?
inside, then of course there's a question of your right to be inside, whether you're a lawful visitor or a trespasser. If you break in, well, I mean, obviously that's an extreme example, and you take photographs, well, you're going to get into trouble for breaking in and be an argument that the photographs you took were unlawful. But if you're invited in by a tenant into that part of the building where the tenant has lawful occupation, well, then the tenant can give you permission. And I don't see that it's open to the freeholder to say, well, you had no business going into that property. If the freeholder has granted a tenancy and given exclusive occupation to part of his building to a tenant, then it's up to the tenant whether you go.
You remember under Section 8, both the tenant and the adjoining owner are entitled to a letter for that requiring access. And therefore, if they say, oh, the tenant says, well, yes, you can come, but you can't come today, and they're being difficult, then you would serve your Section 8 notice on them. I think that's it. I suppose it was exaggerated, wasn't it, during the pandemic, when people quite right said, I don't want you coming around my house.
I thought that was fair enough. I was so hands-off in the pandemic. I was like, look, whatever you need me to do, you know, mask, gloves, whatever, you know. I mean, that's almost, you have to be very respectful when you're going into people's properties, which I think most surveyors are, to be fair.
Stephen, do you mind if I just pick you up on your Section 8 point?
Yes.
Unfortunately, Section 8 is specifically worded: a building owner, his servants, agents, or workmen may, during usual working hours, enter and remain on any land or premises for the purpose of executing any work in pursuance of this Act. So, no, you can't rely on Section 8 to go and take photographs. Unless you're saying that taking a schedule of condition is work in pursuance of the Act.
Yes.
Which might...
I believe it is.
Oh, I see. Well,
I would disagree with that, but that takes us to our next question, which really is to do with final and further inspections. Is there anything, lastly, that anyone wanted to say on the 10.4 and what surveyors should be doing to settle a deemed dispute? Because I take... if I'm appointed under Section 10.4, I would audit the scheme and look at things that I think could essentially aggravate an adjoining owner. I might look at trespassing features, I will look at access, and I will question it and try to add value to the process, which is what I think you're required to do if appointed under Section 10.4. So I see it as, I am here to protect that adjoining owner, and that's a really, really important role. And as Edward and I have discussed previously about impartiality, I believe that if I'm appointed under Section 10.4, I really need to understand if there's anything I can possibly do to help. That's what I should be doing, and I should be identifying issues. But at the same time, what I find sometimes a little bit difficult, potentially, is dispute creation by surveyors who it's unlikely to happen under a 10.4 scenario, more or less because the building owner surveyor tends to appoint a surveyor that he would find sort of relatively agreeable, in terms of aligned views and agreeing awards fairly sort of quickly. But I do think that there can be a risk of the creation of disputes by surveyors, and that's sort of particularly prevalent when it comes to deemed disputes, where the surveyor almost has to guess what is the thrust of the dispute here. I don't think that's that easy to actually deal with when when you're leaving it to a surveyor to identify a dispute. Should they just be saying, well, because it's a deemed dispute, should I just be doing the bare minimum in terms of protecting the adjoining owner and saying, well, look, they haven't responded, they don't really care, so let's just make sure everything's kind of okay and leave it at that. Or do they need to be hands-on and just say, well, actually, no, I'm going to act as if almost like I am the adjoining owner, put myself in their shoes and say, well, okay, well, what's this access? Tell us about it. Where's the hoarding? What are you doing? How long are you going to be there for? So I find that, you have to be fairly intrusive to really ensure you're adding value to the process and that you are protecting the adjoining owner, whilst also balancing it without taking, not taking it too far and saying, well, actually, yeah, let's just get a checking engineer. Why not? Let's get a CCTV survey. Like, you can throw a lot of things into the mix, can't you, for your own safety, where it's easy for you to say, isn't it? But there are cost implications to the building owner, and you don't know that the adjoining owner would necessarily want this anyway.
Well, the answer to your question is that when you're appointed, the Act doesn't distinguish between the roles as a surveyor that's been appointed in the normal process to one that's been appointed on 10.4. So, by implication, you do all that is reasonable to actually. And when I was a young surveyor sometime last century, I used to have a piece of paper, draw a line down there, rights, obligations, and that is your balancing act, to excuse the pun. You're recognising rights, but what the obligations is undertaking, and that's what you must be doing. So, without getting into impartiality, that's the way.
We've done it. We've done it.
Yeah, but I think Stephen is rather beautifully coming into impartiality, because if you're appointed under Section 10.4, and you believe that you should act impartially, there's no problem. You act as you would had you been appointed. If you believe in partiality, then it's rather different, because you haven't got an owner who is giving you a steer into how you might act in a prejudiced or biased way. You're going to have to invent that for yourself. Puts you in a difficult situation, I would suggest, Ben. But
I would say if you're
that's your line.
Can I make just 2 points before we move on? Yeah. So, Edward, what I was referring to under Section 8.5 is the surveyor's access. So, a surveyor appointed or selected under Section 10 may, during usual working hours, enter, I think this is
right.
remain on any land or premises for the purposes of carrying out the object for which he is appointed or selected.
Oh, yeah.
So
that would cover, the object would be...
With the building owner, it's different. It's to do with the works, isn't it? This is the surveyor, his or her duty, which causes is type for another time. When appointed surveyors send their assistants around, technically, they don't have jurisdiction to go around there, the assistants, unless it's with the agreement of the adjoining owner. And of course, you were quite right. Surveyors aggravate or create a dispute, don't they? And they start quoting things like, well, you're not giving me access, that's an offence under Section 16, you're preventing me. Yeah. Well, Matthew Heatham, quoted in Nick Isaac's book, did a Freedom for Information and found out how many times that order to grant them access has been put forward since 1996, and it was 4. So
I'm surprised at that many, actually.
Yes.
What happened, I wonder?
Yeah, that's right. But interesting, isn't it? So you're right. You don't threaten them with Section 16. You make a note in your award that access wasn't possible. It's part of that speaking award. So if a judge sees it, says, well, why didn't they inspect? Oh, I see. All right. Well, they tried their best, which is I suppose the way to finish off that last question.
Yeah,
what can you do?
Agree, yeah.
Okay, so sorry, I keep jumping back and forth.
We'll move on to the next question then. Can surveyors legally award final or further inspections with payment up front? So there's sort of two bits there.
What a question.
In my opinion, surveyors cannot legally award final or further inspections, particularly with payment up front. So at the very least, if I had to concede the first part and say, right, well, okay, we can award final or further inspections, I don't really think you can do payment up front, realistically. But can we legally award it? I would say not without the permission of perhaps the building owner who's going to be paying for this, in my opinion, or the adjoining owner may wish to pay for it. I don't think I think we're too casual about all of this, and we're just saying, well, do you know what, let's just do a final inspection, add on another 400 quid to the fee, lovely money. Surveyors love it. This is why I'm unpopular, by the way, one of the reasons. It's not the only reason. But what I'm saying is that actually, what's wrong with us just being sort of a little bit more accountable and saying, well, what is the reason for this final inspection? It's absolutely fine, right, if you've got someone that is not capable of checking the condition of their property. Like someone that's vulnerable, or someone just wants a bit of reassurance. Like, there has to just be that little bit of a reason, I think, to justify this. And I certainly find it very difficult legally to pay for something up front, like a final inspection, when the very award itself says that the building owner may or may not carry out the following works, and you're like, yeah, exactly. Like, you know, they might not even do the works. Most of the time they do the works, but not all the time. And then you're going to have this, like, a lot of the time I don't even think final inspections are done, quite frankly. Like, I actually think it's a bit of a scam in the industry with these final inspections that inflate fees. And quite
Probably not so
often
much a
they're
scam as
simply not done.
negligence. And,
It's nice to say negligence because it's, oh, I neglected, I forgot, oh, my bad, I was so busy. But the reality is, if you know time and time again that you're not going to do these final inspections, why are you charging for them? At that point, it becomes a scam, in my opinion.
Well, if you're charging for them and not doing them, that's just blatant
But I
dishonesty.
know that happens.
That's fraud. But
can I jump in?
that's as simple as that, isn't it, Steve?
Yeah. I mean, are we just working on the premise that we can award interim, maybe final inspection? We're not.
No, we're not. No, I think you
So
have to
I'm going
justify
to
it.
tear that
I
off
think
the
you
quote,
have to.
yeah.
Yeah, you did an article on that, didn't you? And
I did. Not least, first of all, working for the premise are, well, it doesn't mean it's necessarily right, does it? But it's in all the templates. The RICS template refer to it, but that's no answer. But in that article that I wrote about interim and certainly final inspections, I went back to Hansard, and they were talking about final inspections, and then I spoke to Graham North, who was speaking to John Anstey at the time, chairman of the Working Party, advising the Earl of Lytton. And I said, well, you must remember those conversations when you used to come back from a day's slog and actually working on this. What was the intention? What was the intention of the legislators? And he said, to have final inspections. And Anstey wrote the 4th edition of his book, hot off the press, immediately after he'd finished his work, and talked about interim and final inspections. So for there, if a judge, and I know it's one source that judges do use, in the absence of anything in any of our authoritative books here, what was the intention of the legislature? It's in Hansard. It may not be pretty well, so that's one argument, and you know, I'm not so dogmatic and disagree, but I felt the research was there, and the information from Hansard and from somebody actually spoke to somebody who was involved on the Working Party, that was intentional, and confirmed in the 4th edition of Anstey's book that they're there. But I think that the really good point you make, and I like to think people consider I'm reasonable, and people have raised eyebrows with this answer, but I spoke to Nick Isaac about this, and he provided legal opinion for me because there was such a dispute. And this is going back, when was it now? This is the email, 2016. And he said, dear Stephen, he said, it's an interesting question. I actually wrote, and bearing in mind, Nick may have changed his opinion. He's got bearing in mind, this is 2000.
Perhaps he'll watch this and tell you whether he has.
That's right. But this is what he said at the time, because he said, I wrote this article, Nick did, in Whispers, the P&T newsletter. And he said, although there could be no objection to an award dealing with fees incurred down to the date of the award, it is arguably wrong to make provision for the payment now of fees which have not been incurred at the date of the award and may never be incurred. It is suggested that it will normally only be appropriate to make an award of fees in relation to future inspections where the surveyors are confident that such inspections are both necessary and will actually take place. And the RICS then, as it is now, includes for the RICS template, includes for these inspections. Now this is the interesting point that it came back with, which I have been using and I could be wrong and it could be challenged eventually, but it wasn't, this award, it wasn't challenged. The use of the word incurred, says Nick, relates to liability, not payment. There are, it seems to me, two ways of justifying an award for payment for a future inspection. One, incurred, whilst this is in the past tense, can be said in the context to include future fees being incurred as well, and or perhaps more convincing, his second point, fees are incurred when liability to pay them arises. In the party wall context, if a decision has been made by the appointing surveyor that a final inspection will undoubtedly be necessary and will in the normal course of events take place, liability on the part of the building owner to make that payment has, at least very arguably, already arisen when that decision was made. Consequently, the fee has been incurred and can quite properly be incurred in the award. And he put that into Whispers, and as of 2016, I say he may have changed his opinion since then, that was his view then. But he sums up, he says, in all circumstances, I would suggest it's quite proper to include a provision for payment for fees for one or more future inspections, provided that the need for it is quite clear, so that's speaking award, and it is clear that they are likely to take place. To be properly cautious, says Nick, one might add the sentence into the award, providing that in the event that such an inspection does not take place, the appropriate owner and/or surveyor shall refund that portion of fees representing the costs of the final inspection.
So, I mean, I would say that we're in a position where we're just actually, the surveyors, we're awarding ourselves cash, more or less. We're just saying, yeah, we'll do the final inspection. We all know
You're
the
not Ben.
We all know
You're
the
not
temp.
Ben.
I don't, you know, I in my awards, I do not say that, in my own awards, I do not allow a provision for a final inspection with, you know, just all chucked in together.
If I may say so, that's a matter for you, but may I remind you of section 1013, because that's, I think, quite important. The reason, section 1013 reads, the reasonable costs incurred in A, making or obtaining an award under this section, B, reasonable inspections of work to which the award relates, and C, any other matter, shall be paid by the parties as the surveyors making the award determine. Now, there's a specific recognition that there may be inspections of the work, and if the award is authorising works to take place, those works must necessarily be in the future, and yet the Act, and when the Act says the reasonable costs of reasonable inspections of the work may be included, well, I don't think there's any real problem. You can say there should be inspections of the works. Maybe in appropriate circumstances you would have several inspections. You would have inspections after excavation, inspections after construction up to ground level, and further inspections on completion. And as long as those are reasonable, well, then you can get the costs of those inspections necessarily in the future, because the Act says you can.
Interestingly, though, we did speak about continuity of appointments.
May I remind you of the provisions of section 10, subsection 13. This provides that the reasonable costs incurred in A, making or obtaining an award, B, reasonable inspections of work to which the award relates, and C, any other matter arising in dispute, shall be paid by such of the parties as the surveyors making the award determine. A reasonable inspection of work to which the award relates must necessarily, I would have thought, relate to future works. And the Act clearly envisages that there may be such inspections, so it's difficult to argue that you can't charge for it, and clearly relates to future inspections, and you can include it in the award. It doesn't actually say that the award should say, well, you can only charge for it after you've done it. So it is, I would have thought, well arguable that your award can not only provide for inspections, and there may be several inspections, for example, once the excavation has been completed or asserted to be completed, once the construction's gone up to ground level, and final inspection when all the works are complete, and provided several inspections are reasonable, then you can have more than one inspection, and those inspections can carry a fee, because the Act recognises that they might, and that fee can be included in the award. Nothing in the Act to say the award must make clear that the fee can only be paid after the inspections are carried out. But may I suggest that reasonable surveyors might specify that there will be future inspections and the fee will be whatever, and need only be paid after the inspections have been carried out. Otherwise, the surveyor might be accused of being fraudulent if he's taking fees and then not doing the work.
Can I make two quick points? Just one is that, interestingly, what everything you've just said suggests the continuity of appointments.
It does.
Which is something that we spoke about before, so I feel like that reinforces it.
It does.
So just to bring us back to that. And the next thing is obviously we've used the word reasonable in terms of allowing for a final inspection, and we appreciate that most often it's the case that it is reasonable. again, I could take us back just only for a second to section 10.4, the question where we had what steps should a surveyor take to settle a deemed dispute. And interestingly, a surveyor under 10.4 often doesn't get the opportunity to inspect the property. You know, maybe it's 50-50, I don't know, but quite often they're simply not going to get access. So in that particular case, I would argue it's unreasonable to allow for a further inspection on the basis that the probability is that you're not going to get in. But what I'm saying is the default position for most surveyors is without question, simply just to allow for a final inspection, whether it's a 10.4 appointment or any other appointment, without questioning the reasonableness of that action. I accept most of the time it is reasonable, by the way, but I just feel like we need to work a little bit harder.
What I'm going to say, this article I wrote here about, you know, it could well be removed in later revisions, but what I did say at the end of that, on a practical level, professional level, Ben, I have difficulty in my organisation because I feel we are exposed to a claim under our PI insurance if we don't make that final inspection, and or a complaint to the RICS. And because, referring back to Stephen Smith again, he talks about, doesn't he, it's taken the conveyancing lawyers over 20 years to realise that when there's a sale of a property going ahead, they ask the usual questions: have you got guarantees or double glazing, rising damp? And the Law Society wrote to the conveyancing lawyers, and Edward's dear lady was she maybe a conveyancing lawyer?
Oh yes.
So reminding them that you should also be asking about party wall matters. Were notices served, awards made? Now, half of my practice goes out and every day does surveys on pre-purchase surveys, and they have a vendor. Oh, we've got a party wall award here. It's all done and dusted. And they look round and there's damage that hasn't been noticed. There's been trespass that hasn't been picked up on base extensions. And therefore, you know, what are we doing if we're going around preparing a schedule of condition? If there's no risk, why on earth are we bothering with a schedule condition in the first place? So the schedule condition remains unopened, and you remember, remains open. And as the Earl of Lytton said when he was talking about access, because remember, access was not actually defined for a surveyor in the previous Act. Somehow we got away with it. But the Earl of Lytton said there's two reasons to make your pre-award inspection: to assess the building works and the implications that they may have, and to prepare schedule conditions. So it was twofold. So if we feel it's necessary at that stage to go round and assess the potential damage to the property and the implications of raising a party wall, why on earth are we leaving it open-ended at the end? What on earth are we doing? And the bit I do feel uncomfortable about is where it's a relatively small job, but that's not being hard. That's not my problem. You know, when you are designing, Mr. and Mrs. Building Owner, a small extension, you think, goodness me, the cost of the party wall services is going to be disproportionate in the cost of it. I'm sorry, but
you haven't seen surveyors' fees recently. My goodness, they're taking up a large chunk.
I know, but that's something for us, maybe a redraft in the Act to sort out. But I feel uncomfortable professionally, and Stephen refers to it. You know, surveyors have got to, and that's what Anstey said all those years ago. You've got to, as best you can, draw it to a conclusion. You've considered that there's a risk to prepare schedule condition in the first place, so you've actually recognised there is a risk, albeit small, but what may be considered a small risk to us as surveyors is a colossal concern to the poor old adjoining owner.
No, I agree.
And when they're coming to sell their houses, as at my pre-purchase team are discovering, there's lots of inconsistencies and things that haven't been dealt with. And to me, we're not doing our jobs properly for both parties if we're not undertaking these final inspections, and we should be paid for it.
Yep. I think that the only thing that someone might counter you with would be the idea that it's dispute creation when you know, you've settled a dispute, you've served your reward, and then, as you were saying before about Stuart Frame, it's almost like stepping back now. Your job's done. The opportunity then to, you know, find issues and you know, create work comes about from a final inspection. But I totally get why you're saying everything you are, and I do think most of the time a final inspection is necessary, and it's absolutely fine to have it in an award. It is a reasonable step to take. With that, I'll just advertise your great article, which is I mean, there's 2 articles in this fantastic book. I'm not going to mention the impartiality myth, but we've got Stuart framed the extent of the party wall surveyor's jurisdiction under the Party Wall Etc. Act 1996. That's the 6th article in this book, and it was a very good article that I read prior to us doing this talk. And then we've also got a great one by Dr Stephen Cornish. Schedules of condition and final inspections, are they required under the Party Wall Etc. Act 1996? So that's further reading for people. Should we move on to the final question? Yeah. What can be done, if anything, to ensure surveyors act within their jurisdiction? For me, I posed that question on the basis of looking to add value to the party wall community to see what collectively we can do maybe a little bit better. And what I mean by that is so many cases come out through surveyors acting outside of their jurisdiction. I mean, that you know better than anyone. Yeah. I feel like that must be the predominant cause of appeals. And
you're putting it a little high there, but nevertheless, there are plenty of examples of surveyors not asking themselves, am I entitled to do what I'm about to do?
And again, when we look at the legal cases, it does, you know, Shah versus Kyson is an example, acting outside of your jurisdiction because you believe that the act could be invoked when it couldn't, you know, through section 10 straight off, you know. And we keep on, like, jurisdiction is so important. Going back to Evans versus Patterson, you know, there was no claim and rejection, so there was no dispute. So again, surveyors are going past their jurisdiction, and it just happens again and again and again for so many cases that I sort of look through. I feel like I could do, like you were talking about a column before, right? I feel like I could do jurisdiction versus, you know, the percentage will be quite high, I feel it's such a big issue, and I'm just wondering what, if anything, could be done aside from, you know, educating surveyors about and I'm not one to educate, by the way, but just trying to understand what the parameters are, you know, what is our jurisdiction and how do we actually deal with it?
Well, without, and you sitting in front of me, things like this are really helpful, really good starting point, and it's, but it's limited, isn't it? We realise it's limited because once those surveyors are out there, they're on their own, aren't they? And there's no doubt many cases where they have exceeded their jurisdiction and no one has picked it up yet. And if it's an award, the award itself is bad, it could be challenged successfully despite, you know, it's not related to that 14-day period, isn't it? If the award is ultra-virus, that's it. But no one ever picks it up, do they? Apart from my colleagues that are actually up there doing these pre-purchase surveys. But of course, unfortunately for the parties, the only way to say what can be done, if anything, to ensure that the surveyors act within their jurisdiction, well, if the radar is up on the part of one surveyor, or indeed or both parties, there's 10, 11, isn't there, the referral to the third surveyor. And I'm constantly being asked tricky questions about jurisdiction. I don't believe the surveyors can be doing this. So, you know, it's not all, you know, it's the potential risk of costs involved, but I do offer, and we had this conversation before, you know, referring to section 1010, that the agreed surveyors, or the 3 surveyors, or any 2 of them, can make an award. If I do not feel that the dispute has gone beyond a 1010 situation, and it's going to the acrimonious 1011, potentially acrimonious 1011, I invite them to have a Zoom session with me, the 2 surveyors, and say, look, you know, I can join with you, I can give you some advice. If one surveyor feels uncomfortable about that, and I accept that, say, well, I can't do any more, but I make that offer. You know, for me, Alex Frame, Stephen Campbell and ourselves did a 3-part podcast series for the faculty about going to the third surveyor, and one of the episodes was making better use of the third surveyor. And it doesn't always have to be that acrimonious dispute that leads to costs. It can be my offer of half-hour free consultation on a Zoom session to actually talk to them, say, well, what is the problem here? What is the problem? But that it takes a great deal of, and I don't always get it right, but it takes a great deal of judgment on my part. I may have not realised that it's gone too far. But nevertheless, I do, and I have resolved quite a few cases, I say so myself, that way. It's, look, try looking at that. You're almost there now. Get over the finishing line. And we even had the parties involved as well. And without being disrespectful to parties, because, you know, it's each their own, isn't it? But when I get a submission from one of the parties, it's like reading a stream of consciousness sometimes. You've got to go away and read Ulysses to prime yourself for it. But so long-winded answer, Ben, but 10-11 or 10-10 is one way of dealing with it. Training, and of course the sessions like this, but also, and Edward's running a wonderful mediation scheme now, realising the costs of appeals, that you can appeal the award but with a stay, and I may be wrong there,
that's right,
and going to mediation to try and an alternative dispute resolution process. But constant, the faculty and P&T are constantly giving lectures, aren't they, and seminars, e-bulletins, newsletters. That's the only way we can do it, constant. And
you can write a guidance note, I suppose.
Yes, but that's, I don't know whether that answers your question. But
no, I think it does. I can't see anything else like, that's a magic bullet that's going to sort of deal with this, aside from the fact that you've got two good, strong professional bodies that will put forward their messages regarding jurisdiction. I think that's really absolutely vital. And then for me, it's about sort of, if anyone wants to be a party law surveyor, they should be engaging with what I think on the whole is a helpful community where we talk, we discuss, we learn, and we try to go through it all together, specifically with, say, jurisdiction in mind, but also other issues as well. It's good to talk, basically, to learn and then to form your own views. But yeah, I don't think that there's anything strongly that we can do other than just almost act persuasively as people talking and giving opinions and using our experience. What do you think, Edward? Sorry.
No, that's exactly right. Quite frankly, what we need is a new Party Wall Act, which affects a number of changes in the current one. But the most important change would be the definition of surveyor.
Yes.
And to prevent any old Joe so being a surveyor. And if a surveyor has to have a particular qualification, either by, through the Royal Institution or other chartered body, or through some separate scheme operated through the relevant government department, it would then be possible to bring in a code of conduct, and surveyors who fail to meet that code can find themselves suspended or even removed from the list of qualified surveyors. And that all introduces a really quite substantial body of law and professional qualification, which I suppose many surveyors would object to, because it would involve ultimately them having to belong to a particular body, and that will involve an annual membership fee and so on and so forth. But there are models available, one close to another part of the law which I get involved in, are qualified insolvency practitioners. There used to be a time when anybody could act as an insolvency practitioner. And since 1996, that has not been possible. You have to be qualified, and you can get your qualification through a professional body. You don't have to get your qualification through the Secretary of State. It really depends on whether there is a sufficient problem countrywide from incompetent and inexperienced people acting as surveyors to make it a sufficient scandal for Parliament to feel that something needs to be done. And whether we're there or not, I don't know. I mean, my problem is that I come across the problem cases.
Yes.
I don't see the day in, day out Party Wall Award perfectly well done and goes through without any great expense, and the parties are perfectly happy.
And they still go through. And
well, that's fine, the problem.
And it's not always a problem, if that makes sense.
No, you're quite right. Of course, because surveyors are dealing with parties who, by and large, know absolutely nothing about the Act and nothing about construction. The quality of their work is not being looked at by somebody who can assess it.
You're quite right, Edward, and I believe it needs a chartered regulatory body to actually register these surveyors. And if governments had not been preoccupied by COVID, financial crisis and everything else that's going on, I'm pretty sure that because of the amount of complaints that are coming from the public, they would go at it in much the same way they did have a go at valuers and estate agents a few years ago. I'm a chartered building surveyor, but I was, when I used to be doing building surveys and house purchase surveys, I also used to do valuations. It's a very good add-on to the end because you assess the effect of the defects on the value of the property. And all of a sudden the RICS come along and say, well, you're going to be doing these valuations now, all you surveyors. You've got to be a registered valuer. And you've got to submit details of what you've been doing, how much you've been valuing, have you had any claims, and we will audit these once a year. And we took umbrage against that. I've been doing valuations for 25 years, I don't know if you're asking me to do that, but we had to fall into line. And that I feel that if complaints continue from the public, that if and when a government of the day has time, they will actually probably start thinking about a regulatory system, and probably not too dissimilar from this registered valuer scheme, because you cannot undertake property valuations unless you're a registered valuer. These red book valuations, mortgage valuations, property valuations, commercial valuations, and if you're struck off, that's it. You can no longer practice, and it may well come to that one day.
The only thing I would say about that is there has to be some sort of regulation, I think, but the reality is you've got the RICS, and it's very hard to be struck off. Very hard, I would suggest. And we also have like people at the top that are fully like accredited, qualified, that they've got all sorts of letters before and after their names, and yet they're involved in some of the most prominent cases of failure, really, when it comes to party wall matters. I'm not going to name anyone, but people at the top, you know, at the top of both professional organisations that we have today. So I don't know whether there's a correlation between, you know, a surveyor's behaviour and belonging to a particular body.
The RICS, well, the difficulty of relying on the RICS, that means that excludes architects and engineers. That's why there must be, chartered surveyor, there must be a separate regulatory body that incorporates engineers, architects and surveyors who want to be party wall surveyors. The RICS do not have domination over who can be a party wall surveyor, and it would be up to that regulatory body, because there's no doubt about it that since that Red Book registered valuer scheme came in, the amount of complaints has gone down. You're never going to eliminate them, Ben, are you?
Yeah, no,
but there'll always be the difficult ones. But it's a step, isn't it? And it can, as Edward's already said, it's more than one process. It's a new act, bringing the act into the 21st century. You know, this is relying, you know, when I was looking at this Selby case and I was doing research, you know, there's many things from 1850 that went into 1894 that was then transcribed into 1939, you know. So, great piece of legislation for the time, but it does need updating because events have overtaken it, hasn't it?
Agreed. Right, shall we wrap that one up?
I think we should.
Thank you very much.
Thank you, Ben.
Cheers.
Thank you, Edward.
You're very welcome.
And that's a wrap. Thank you so much, Steve and Edward, for taking the time out of your busy schedules to be here with us today. To those of you watching, we really hope that you found this useful and thought-provoking. If there are any guests or topics that you would like to see, please get in contact with Ben. Thanks so much.